Good day viewers, welcome to another edition of the Daily Strange Stories. I'm John Brown. I hope you've had a productive and fulfilling week. Now, let's dive into the strange and unusual. Our lead story for today: NPA boss caught lying under oath, Advocate Tembeka Ngcukaitobi grills and tears apart Shamila Batohi's testimony. In the heart of South Africa's legal system, a dramatic showdown unfolded yesterday at the Nkabinde Inquiry, where the head of the National Prosecuting Authority found herself under intense scrutiny. Advocate Tembeka Ngcukaitobi, who is representing the suspended South Gauteng Director of Public Prosecutions Andrew Chauke, launched a relentless cross-examination that exposed what he described as serious falsehoods in the testimony of National Director of Public Prosecutions Shamila Batohi. This confrontation highlighted claims that Batohi had not been truthful under oath, particularly regarding the advice from an expert reviewer and the setup of the very inquiry they were part of. As the session progressed, Ngcukaitobi methodically dismantled Batohi's statements, revealing inconsistencies that raised questions about her reliability and the integrity of decisions affecting high-profile cases. The inquiry itself stems from concerns over Chauke's handling of major prosecutions, including the racketeering charges against former KwaZulu-Natal Hawks head Johan Booysen and the stalled murder case linked to former crime intelligence boss Richard Mdluli. Established by President Cyril Ramaphosa, the panel led by Judge Bess Nkabinde aims to determine if Chauke remains fit for his role. Batohi, as the National Director of Public Prosecutions, played a key part in recommending this probe, but yesterday's proceedings turned the spotlight back on her own actions and words. Ngcukaitobi's approach was precise, using documents and prior statements to challenge Batohi's account, suggesting she had misled the panel to protect her position. One of the central accusations focused on Batohi's description of a review conducted by Dr. David Broughton, an advisor brought in by the National Prosecuting Authority to examine Chauke's decisions. Ngcukaitobi pointed out that Batohi had claimed in her evidence that Broughton had not addressed the Mdluli matter at all and had offered no opinions on it. However, evidence from Broughton's own reports showed otherwise. In two distinct opinions, Broughton had delved into the details of the Mdluli case, which involved the 1999 killing of Opara Muhiba. He had analyzed the failure to pursue charges against Mdluli, even suggesting that the National Director of Public Prosecutions should consider referring Chauke to an inquiry for this oversight. Ngcukaitobi argued that Batohi's statements were not just mistaken but deliberately false, as she had summarized Broughton's work in a way that omitted these critical sections. Batohi defended herself by explaining that her interpretation differed. She maintained that when she said Broughton had not dealt with the matter, she meant he had not provided a definitive recommendation, rather than ignoring it entirely. Yet, the documents revealed Broughton had explicitly stated the need for further action, contradicting her summary. The exchange grew tense as Ngcukaitobi pressed her to admit the discrepancy, but Batohi held firm, insisting her understanding was based on the overall context of Broughton's affidavit. Judge Nkabinde stepped in at one point, noting that the disagreement seemed rooted in how words were interpreted, and she indicated that the matter would be resolved through later arguments. This part of the cross-examination underscored how Batohi had not drawn the panel's attention to key paragraphs in Broughton's reports until forced to do so, which Ngcukaitobi used to bolster his claim of deception. Shifting gears, Ngcukaitobi turned to the terms of reference for the inquiry, which Batohi had helped draft and recommend to President Ramaphosa. He accused her of trying to distance herself from the final version by claiming it differed significantly from her office's proposals. Documents presented showed that a draft prepared by Batohi's team was nearly identical to the one gazetted by the president. Batohi initially denied recommending those exact terms, but under questioning, she conceded that her office had indeed sent the draft. She explained that she had been referring to an earlier version when she made her previous statements, pointing to multiple iterations in the drafting process. This revelation suggested an attempt to downplay her direct involvement, especially since the terms outlined the scope of investigating Chauke's actions in the Busen and Muli cases.
Now, can I then move on to another topic, just to understand these charges? My understanding of the way in which these terms of reference emanated is that you drafted them and the president endorsed your draft. Is that correct?
Well, actually what happened is we went and checked this after. We did submit a draft to the president, but what the president adopted subsequently is quite different from the draft, and we didn't input into any draft that the president had. So there is a difference between the two.
All right. Well, I have not seen the draft you gave the president, and maybe you should send us that draft, because I understood all along that the president endorsed the draft that you gave to him.
No, that's not the case. We can let you have the draft.
Yes. Now, can I then go to making sure that I understand?
I beg your pardon. Advocate Batohi, what is the answer? You're saying Advocate Nkcukaitobi can have the draft.
That is correct.
Do you have it?
We do have it.
Thank you, Madam Chair.
Has it been made available to the evidence leading team, that draft?
I'm not sure if it has.
May we ascertain whether the draft document that was sent to the president as regards the terms of reference has been made available to the team? May
Sure.
I just verify with Advocate Mdluli? Has it been made available to you?
Madam Chair, I'm not aware of any draft. All what I'm aware of are the terms of reference that have been gazetted.
I still have one more question on the issue of this draft. Advocate Batohi, I want to confirm whether it is your testimony that the draft you gave to the president is different to the terms that the president finally signed.
That is correct.
Yes. And you cannot at this stage tell us what the differences are.
I can't.
Yes. All right. Can we then go to the terms of reference that the president endorsed? Because I am not understanding them.
A particularly pointed moment came when Nkcukaitobi questioned why the terms did not explicitly state that Chauke had exceeded his authority in the Busen matter. The racketeering charges against Busen and members of the Cato Manor unit had been invalidated, and Chauke's defense of them in court was under review. Batohi acknowledged that the precise phrasing about acting outside jurisdiction was absent, but she argued that the accompanying documents implied it clearly. When asked about the omission, she admitted she did not know the reason, suggesting it might have been a mistake in drafting. Nkcukaitobi seized on this, implying that the inquiry was now being used to correct oversights from Batohi's own team. She refused to engage deeply with this characterization, simply noting a disagreement on the point.
It reads, the institution of the racketeering charges in terms of Section 2, Subsection 4 of the Prevention of Organized Crime Act 1998 against Major General Booysen and members of the Cato Manor unit, and the defense of those actions in subsequent review proceedings brought by Major General Booysen to have the racketeering certificates set aside in that. Now, there are a couple of points that arise from that. The first one, is that charge limited to racketeering, or does it include the predicate offenses?
Racketeering, by its very nature, includes predicate offenses.
Yes, but you know what I'm asking you. I'm asking if the murder charge standing alone is included or excluded. And if I can give you an example to make it easy. Major General Booysen is charged with 7 counts. 2 of racketeering, 2 of murder, 1 of defeating the ends of justice, and 2 of violating the provisions of the Firearms Control Act. My question is a simple one. Does that charge exclude the 2 murder charges, the 1 charge of defeating the ends of justice, and the 2 charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batohi, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Booysen.
It does not exclude it in the context of racketeering.
Advocate Batohi, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. But I'm asking you is that Major General Booysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer, is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. If you withdrew racketeering, Major General Booysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
so when I did withdraw the racketeering...
No, I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Booysen should not have faced the murder charge?
Not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Booysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Booysen.
Yes, those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Booysen with murder?
My understanding is that Major General Booysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
The Busen case itself provides crucial background to these exchanges. It involved allegations that Busen and his unit had engaged in racketeering through their handling of various incidents, including the deaths of 28 individuals. Chauke had authorized the prosecution, but later reviews found insufficient evidence, leading to the charges being set aside. Batohi's position was that Chauke had pursued these without proper grounds and beyond his jurisdictional limits, as the matters fell under KwaZulu-Natal's purview. Ngcukaitobi countered that there had been evidence at the time, including 23 murder dockets that were not provided to the KwaZulu-Natal Director of Public Prosecutions, Siphiwe Mlotshwa. Batohi confirmed that those dockets were missing, which might have influenced decisions, but she stood by her view that no justification existed for the charges. In the Mdluli matter, the inquiry is examining why Chauke did not advance the murder prosecution related to Ramaphosa's death. Mdluli, a former high-ranking official in crime intelligence, had faced accusations, but the case stalled. Broughton's review had highlighted this as a potential failing, recommending inquiry referral, which directly opposed Batohi's initial testimony that he expressed no view. This inconsistency formed the core of Ngcukaitobi's accusation that Batohi had lied to the panel. Earlier in the week, the cross-examination had already touched on Batohi's early decisions after taking office in 2019. Ngcukaitobi highlighted a meeting on the 6th of March, 2019, just a month into her tenure, where she discussed potential disciplinary actions against prosecutors involved in the Busen case. Minutes from that gathering showed Batohi criticizing the National Prosecuting Authority's conduct and suggesting measures against members of the Priority Crimes Litigation Unit, including figures like Advocate Sello Maema and Advocate Kulegani Matendra. Remarkably, she had invited Busen's legal team, attorney Carl van der Merwe and senior counsel Anton Katz, to this meeting without first consulting her own staff or the families affected by the Cato Manor incidents.
My initial response was, in fact, I really don't remember, but having thought more, I'm inclined to think that I did not get it from him. But, of course, you are most welcome to speak to him, and we will also check our files to see if there's anything to that effect. But we're certainly not suppressing anything.
Now, My instructions are that, in fact, there was a meeting with Mr. Epstein on the 6th of March, 2019, called by you at your office, which included the state attorney, Mr. Sabele Metza. Do you remember that?
I did have meetings with Mr. Epstein.
You did have meetings
It
with
may have, in fact, been more than one, because he had been dealing with a number of matters in the NPA. And so I just wanted an update on what was going on.
Yes, I'm asking you about one meeting, which is the 6th of March, 2019. Not asking you about other meetings.
All I'm saying is that I did meet with him, and that is possibly also a date on which I met with him.
Now, that meeting, I understand, was also attended by Counsel for Major General Booysen, Advocate Anton Katz.
Mm.
Do you have any comment on that?
Unless my memory is failing me, I can't recall having a meeting with Katz and Epstein. But I'm not saying that it didn't happen, but I really, at this point, I can't remember that.
Well, it would have been a big story on your diary that you have called the advocate who represents the person who is suing the NPA into the same meeting with the advocate who's defending the NPA. I'm not understanding why you cannot remember such a big event.
Well, it may be a big event in your calendar, Advocate, but for me, I meet with lots of counsel, and I cannot recall whether they were both in the same meeting.
So your answer is, I don't remember.
That is correct. I do not remember.
Just like you don't remember if you got an opinion from him or not.
That is correct.
Yes. Now, I am also told that it was at that meeting that you instructed the state attorney to withdraw the opposition to the Major General Booysen application.
What date was that?
6th of March, 2019. I presume you also can't remember.
I can't.
Yes.
Ngcukaitobi used these minutes to show that Batohi had formed opinions prematurely before investigating the allegations herself. She had not reviewed the full docket or engaged with the implicated prosecutors, yet she spoke of their poor behavior and the need for discipline. Batohi explained her stance by referencing the broader context of state capture allegations emerging from the Zondo Commission, which was probing corruption in state institutions. However, Ngcukaitobi pointed out that key testimonies, such as those from Busen and Advocate Muli, occurred after this meeting in April and June 2019. Batohi repeatedly said she could not recall specific sources for the allegations, which Ngcukaitobi interpreted as a lack of foundation. She insisted that public discussions and media reports had influenced her, and she named several individuals now facing processes, but denied having a predetermined list. The meeting also involved Busen's lawyers presenting an amended notice of motion to set aside the racketeering authorizations, which Batohi initially claimed not to remember but later acknowledged. Her prior connections to Busen and Van der Merwe from her time as KwaZulu-Natal Director of Public Prosecutions added another layer, though she minimized these relationships. Throughout the inquiry, other issues surfaced, such as missing annexures in Batohi's submissions. Panel member Matsehu Ramaphosa raised concerns about documents not provided in advance, which Batohi attributed to an oversight by her team. This pattern of omissions and corrections painted a picture of sloppiness in preparation, which Ngcukaitobi linked back to the terms of reference debate. He argued that Batohi's reliance on reports rather than personally reviewing dockets weakened her case against Chauke. For instance, she had not read the full Busen docket before deciding to overturn his decisions, instead depending on presentations from others. Ngcukaitobi emphasized that only the National Director of Public Prosecutions can authorize racketeering charges, making her oversight particularly irresponsible. The inquiry's location at the Master of the High Court in Pretoria added to the formal atmosphere, with Batohi appearing under pressure as she navigated these challenges. Ngcukaitobi also criticized her for mentioning state capture in relation to Chauke without personal knowledge, calling it an attempt to taint the proceedings. Batohi clarified that she used it to explain the environment in which she operated, not to directly implicate Chauke.
Can I ask you another topic? You have repeatedly mentioned state capture in this inquiry. Do you remember that?
I do.
Yes. Now, the definition of state capture as adopted by the commission under Justice Sondo is a misuse of the state and its organs for private gain or for unlawful aims. Do you accept that definition?
Yes.
Do you have any personal knowledge that Advocate Chauke was involved in state capture?
I don't have any personal knowledge.
Yes, all right. So then it was grossly irresponsible of you to mention state capture in the context of Advocate Chauke when you have no personal knowledge of his involvement in state capture.
Should I comment on that?
If you want to, I'm putting it to you that I will argue that you were attempting to poison the atmosphere when you had no evidence, but you mentioned state capture together with Mr. Chauke.
The reason why I did is that I was asked about why I took certain actions when I did. And I explained that because that was in fact the NPA and capture of the criminal justice system was something that the Zondo Commission was inquiring into. And I couldn't turn a blind eye to the fact that that was what was being inquired into, and that as a responsible national director, in my view, I needed to consider all options. And the only reason why I mentioned it is because I was asked about the context and why I took certain actions. And that was what was also something that was on my mind at the time. So I considered all of this, and therefore I took certain actions.
Advocate Batohi, we are in an inquiry against Advocate Chauke. We are not in a state capture inquiry. My question was simple. You've given me an answer. You have no evidence that Advocate Chauke was involved in state capture. Yet you have repeatedly mentioned state capture in the context of this inquiry into Advocate Chauke. That is what I am saying to you is intentionally designed to poison the atmosphere of this inquiry, to create the impression that Mr. Chauke is involved in state capture, when you know full well that you have no such evidence.
I was asked what were the reasons for me doing certain things at the time. And I explained that that was the context within which I took those decisions.
Yes. Anything else to add?
No.
When pressed on whether the National Prosecuting Authority believed Chauke erred in pursuing murder and racketeering charges, she referenced the KwaZulu-Natal Director of Public Prosecutions' finding of no evidence. As the cross-examination unfolded, it became clear that Batohi's decisions extended beyond these cases. She had instituted disciplinary charges against Chauke based on what Ngcukaitobi described as a weak foundation, overly reliant on secondary reports. Batohi admitted that the answering affidavit in the Busen litigation was central to her misconduct case, involving multiple steps, but could not point to additional facts supporting a review of Chauke's conduct. This admission highlighted potential gaps in her approach. The Mdluli case details further enriched the narrative. The 1999 killing of Ramaphosa had long been tied to Mdluli, with investigations stalling despite evidence. Chauke's role in not advancing it drew scrutiny, and Broughton's explicit analysis, twice addressing the matter, directly contradicted Batohi's claims. Her defense hinged on semantics, arguing that dealing with meant something specific to her, but the documents showed Broughton had gone further, urging consideration of an inquiry. In the Busen saga, the Cato Manor Unit's actions involved complex allegations of overreach in dealing with suspects, leading to the racketeering indictment that Chauke defended. Ngcukaitobi argued that Chauke had acted within his powers, attempting to persuade Mlotshwa to sign off, but Batohi saw it as jurisdictional overstep. The missing 23 dockets became a focal point, as they could have provided justification for the charges, yet were not shared, raising questions about internal communications within the National Prosecuting Authority. These elements combined to create a web of accountability issues, with Batohi at the center. Her early meeting in 2019, the handling of Broughton's review, and the drafting of inquiry terms all pointed to a pattern where decisions seemed hasty or selectively presented. The inquiry continues to unpack these layers, aiming to clarify Chauke's fitness while inadvertently questioning the leadership above him. As this story of legal intrigue and accountability unfolds, it invites reflection on the mechanisms that safeguard justice in South Africa. What do you think? Has the cross-examination revealed genuine flaws in the National Prosecuting Authority's leadership, or is it all part of a necessary process to ensure transparency? Share your thoughts in the comments below, and let's discuss how such inquiries might shape the future of prosecutions in the country. Thanks for watching this news bulletin. Please share your opinion in the comments section. We would be glad to read and respond to your comments. Let's meet again tomorrow in our next strange story. Wishing you an exciting and adventurous weekend.